Good morning and welcome to all the members joined in this virtual program on the particularly skill enrichment of the chartered accountants with special reference to constitutional provisions. We have with us eminent speaker, Advocate Kapil Goyal, who is also a chartered accountant. Without anything, we can tell that he's a chartered accountant. He's a chartered accountant whenever we are speaking about that one is particularly, and he will speak about on the his introduction on special lines. We can put it that one as Advocate Kapil Goyal, practicing lawyer at Supreme Court, High Court, tax tribunals. Advocate Goyal is a commerce graduate, qualified chartered accountant, and fellow member of ICI. Advocate Goyal is a specialized lawyer in direct tax litigation. Advocate Goyal has argued some landmark cases at High Court on wide-ranging issues on reassessment and such assessments. Till this time, more than 2,000 cases he had represented at various judicial forums, including High Courts and ITAT. Further, he has addressed more than 2,000 seminars across the country and more than 2,000 webinars at various ICI platforms. Mr. Goyal keeps special interest in constitutional studies and keeps interest in the Constitution of India used by chartered accountant in day-to-day life. With this, I welcome to Advocate Kapil Goyal in this virtual session. He has been tremendous whenever we are talking about the constitutional provision and other aspects. So that with a warm and grand applause, we welcome to Advocate Kapil Goyal into this session. With this, I am handing over the session to Advocate Kapil Goyal for further proceeding. Over to Advocate Kapil Goyal.
Thank you, Mishaji. My dear fellow colleagues who are viewing this virtual program conducted by Professional Skill Enrichment Committee of the ICI, Dr. Mishra, who is the catalyst for arranging this webinar, and everyone who is with me in this program today. My greetings to everyone. And this topic and this particular session has been kept keeping in mind. Few days ago, we have Constitution Day celebrated in the Honorable Supreme Court of India also. And every year, 26th November, we celebrate the Constitution Day. The Honorable Prime Minister of the country, Narendra Modi ji, was also there in the Supreme Court, we saw. And the importance of Constitution in our day-to-day life, in our professional life, in our, all aspects of the life. It's very important to understand how it has a far-reaching implications and how at times we see in our experiences that many times the Constitution of India is not being given that kind of respect or weightage which it should be given. So we have four parts today to discuss. 4 parts we have circulated in the flyer also. That what is the overall importance of Constitution of India in current perspective, and various analysis of widely impacting provisions of Constitution of India, then some illustrations and practical case studies, and then interplay with the tax laws. Being chartered accountant, we have very serious, dealing with the tax laws in day-to-day life. Being a practicing lawyer, I can say when I appear in constitutional courts, especially high courts, I understand and experience what great weight Constitution of India, friends, we have. So today's session has been kept keeping in mind that in the current perspective, how we are facing various issues from regulators and executive authorities. And I will just start my session that all of us, we are God loving. And when we see our great epics like Ramcharitmanas and various other epics, they have some similarities with our Constitution of India. So in Ramcharitmanas also, you will find there has been, when Lord Ram was there, the concept of rule of law and what do you say, governing by highest standards was there. So Ramcharitmanas also tells us something which Constitution of India also tells us. So there can be broad similarities between these two. I'm not a very great, or you can say, even I don't know too well, I don't know much about Ramcharitmanas, but as little as I know, when we go to Sundarkand, when we go to various chopais of Ramcharitmanas, there has been some chopai where you can have similarities or sense of Constitution of India in the preamble to the Constitution of India. So with this note that our Constitution of India is a holy document, and it is that document or book which every Indian takes in its hand and then governs itself, and it is to be the main source of or inspiration for all to govern themselves and conduct themselves, be it government, be it regulator, being it chartered accountants, being it anybody. So it has a very serious pervasive value, Constitution of India. And if I say, I was saying about Ramcharitmanas, there has been some chopai where Tulsidas ji has stated in the Ramcharitmanas that one has to conduct itself in the manner that it is as neutral and as clean as possible. सम्मुख होई जीव जब मोही जन्म कोटि अग नासहि तबहि. That is one of the thing. जब आप भगवान के सामने होते हैं, आपके सारे पाप कट जाते हैं. And there is one more thing. जितने तारे गगन में उतने शत्रु हुए, कृपा रहे श्री राम की बाल न बाका हुए. और एक और बात बड़ी इंपॉर्टेंट, आई से इन हिंदी, सॉरी. देयर इज अ वेरी इंटरेस्टिंग लाइन ऑफ तुलसीदास जी, दैट तुलसी नर का क्या बड़ा, समय बड़ा बलवान, काभा लूटी गोपियां, वही अर्जुन वही बाण. That means that time is the biggest factor. And Arjun one time won a Mahabharat war, and another time he was not able to save himself from the wheels and all those things. So time, man is not big, time is big. And we have to save from our, what you say, bad values, bad things. We have to keep on our values and morals and principles. That is what Ramcharitmanas also tells. That is what Tulsidas ji has also said it. And that is what Dr. B.R. Ambedkar, when Constitution of India was in making. So one can go to those documents and find when Constituent Assembly was debating the making of the Constitution of India, that how great pain was taken by our constitutional framers, sir. That what kind of things they have uh, kept, and even today it has a very serious portent in it. But unfortunately, in today's perspective, in current perspective, it is my respectful and very humble submission that many times I feel as a student of law and as a humble citizen of this country, that in current perspective, in today's perspective, in today's scenario, the Constitution of India, which has to be given maximum weightage, as even Honorable Prime Minister says. But unfortunately, various regulators, various administration, and especially tax authorities, I have seen, and various authorities with whom chartered accountants have to deal, are not able to follow what is stated in the Constitution of India. And I will make good my submission with some case studies, with some landmark precedents, with some judgments and judicial pronouncements which Dr. D.Y. Chandrachud, the former Chief Justice of the country, has written, and which current Chief Justice, Justice Khanna, the Chief Justice of the India, Justice Sanjeev Khanna, has written. So it has to be kept in perspective. At one place, Ramcharitmanas, at one place, Constitution of India, Dr. B.R. Ambedkar vision, constituent framers vision about India and Constitution of India. And at another hand, today's scenario and the tax authorities and various bureaucrats and various regulators, how they are fulfilling the constitutional sense. So friends, whoever is listening to me, I have penned down some words which can bring my topic in perspective, that what is all about the Constitution we are going to discuss in next 90 minutes or 100 minutes. So if I talk about Constitution of India, it's a large document. It has a very important preamble to it, which preamble has in itself a ocean of things in it. That India, we the people of India have to have this fraternity, liberty, equality, and all these things. Justice, liberty, equality, and fraternity are four pillars of preamble, 4 points in preamble to Constitution of India. Justice, liberty, equality, and fraternity. So preamble is a Constitution of India. It starts with 395 articles, 12 schedules. It's a large document. But one thing is very important: the culture of constitutionalism is to be there. Now, what is constitutionalism? Constitution of India is one thing document. It's a holy book for us, as I have stated, and various Supreme Court judges have said that it is that holy book which every Indian takes in its hand and go by, walks in his life. So, what is constitutionalism? How do you define constitutionalism? What is there in the constitutionalism? And how can you understand in the easy sense कि what is हम क्या समझेंगे constitutionalism से? So, friends, I have got one decision of Honorable Supreme Court of India. Maybe some of you are aware about it. This is one judgment of Supreme Court 5-judge Constitution bench. I am sharing the screen. I hope my good technical friend will see that it is there. So I believe it is there. I will just show a paragraph of this judgment of the Supreme Court of India, friends, and I will tell what is the judgment, and just I will come to that paragraph which I want to emphasize about, I guess. This is para 40. Now, this judgment, friends, is 5-judge Constitution bench judgment of Honorable Supreme Court of India. You remember, all of you, that in just few months ago, when Dr. D.Y. Chandrachud was the Chief Justice of India, he was part of this bench. There was a issue regarding Section 6A of Citizenship Act, constitutional validity regarding a provision of citizenship law of Section 6A. This is a 5-judge Constitution bench decision in that case. And the title of this case, friends, if one wants to notice, this is in Section 6A of Citizenship Act 1955. The citation is, neutral citation is 2024 INSC 789. This is 5-judge Constitution bench judgment of Supreme Court of India in the matter of Section 6A of the Citizenship Act. And there are 3 or 4 different opinions by judges. Main opinion is by Justice Surya Kant Saab, and another is by Justice Khanna, Justice Chandrachud and Justice Padiwala Saab. I am on the constitutionalism. Let us not forget where we were. So I want to highlight what is Justice Surya Kant, the majority judgment, the main judgment of the Supreme Court in this case, what his lordship has to say about how you understand. And there is a very interesting paragraph in the judgment. That's why I have opened it and sharing it so that I can put my point in perspective. This is para 40. Yes, it is there. So all of you can have a look at this paragraph. It says the essence of our constitutional system is rooted in the concepts of constitutionalism and judicial review, which comprise 3 essential elements. There are 3 parts of constitutionalism, friends. First, the presence of a written constitution establishing and constraining government organs. Let me take a pause. What is the first element? Presence of a written constitution means there is a written document, then only constitutionalism can come. And we have a written document that is called as Constitution of India, which we are discussing today. And that presence of a written constitution, what it do? It establishes and constrains government organs. Now, establishing and constraining government organ, what does this mean? It means that it regulates various activities of various parts of the, that there are 3 main parts: legislature, executive, and judiciary. So all these are being dealt, what are their area of operation, etc., etc. So for the constitutionalism to be there has to be first a written document, a written constitution, which establishes and constrains the government organs. Constraining is a very important word, which needs to be emphasized and ingeminated. Now, second part of constitutionalism is the constitution is a superior law and a superior standard by which the conduct of all organs is to be assessed. Now, many people, I want to take a pause here. Many regulators, many people who acts as a statutory authorities with whom chartered accountants and as a professional we deal, I have seen that there is a, as I have stated earlier also, there is a little or some lesser respect towards the constitutional values and constitutional constitutional theme and constitutional scheme of provisions. So Constitution is serving as a superior law and a standard by which conduct of all organs is assessed. So many times we feel that statutory authority's role has to be only seen with perspective of that particular statute. Let us say income tax officer is there. There is a jurisdictional assessing officer and there is a faceless assessing officer. So if you have to see the validity of the act of a statutory authority, here we are discussing about income tax authority or maybe GST authority or any other authority, custom authority, then constitution is a superior law and a standard by which conduct of all organs is assessed. So income tax authorities cannot say that we are not to be seen by Constitution of India, or Article 226 writ petition does not govern the actions of income tax authorities. And Article 14 equality provision and equality guarantee goes by, and income tax authorities are free to treat people discriminately at their whims and fancies. That is not the law. So all authorities, be it income tax authorities, be it GST authorities, be it custom law authorities, be it enforcement directorate officials, all are governed by and checked and assessed and reviewed under Constitution of India. Please note it. Constitution is a superior law by which the conduct of all organs is assessed. No authority, be it tax authority, be it custom authority, be it corporate law authorities, be it any authority, cannot say that we are immune from constitutional scrutiny and constitutional constitutional examination. And third part of constitutionalism, friends, is the provision for sanctions to prevent, restrain, and if necessary, annul any violation of superior law. Now, this third element is very critical, which Supreme Court has also said. Third element gives power to constitutional courts. If there is a constitutional violation in any act of any authority or a particular state authority, government authority, then constitutional courts can step in under power of judicial review, which is a very, 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 very important part of today's program, that Constitution of India guarantees every citizen, every person to have a judicial review from constitutional court, which is part of constitutionalism, where a constitutional court sees and checks and observes whether authorities are acting as per superior constitutional mandate or not. Now, this third part of constitutionalism, friends, which is giving power to judicial review to the constitutional courts, which constitutional court in our countries are Honorable High Courts and Honorable Supreme Court of India, are two constitutional courts, can examine under judicial review, part of constitutionalism, whether the state and government authorities and statutory authorities are doing their acts according to the superior law, the higher law, that is the Constitution of India. So I again recapitulate what is constitutionalism. First, the presence of a written constitution. Second, constitution serving as a superior law. And third, provision for sanctions to prevent, restrain, and if necessary, annul any violation of superior law. Now, Supreme Court says, friend, on third element. Now, I want to read this, which is very important. The third element which seeks to safeguard superior law is through judicial review. We will devote some more time on this because this is very important part of today's seminar. What is judicial review? But as part of constitutionalism, what is judicial review? The Honorable Supreme Court has succinctly stated the third element which seeks to safeguard superior law is through judicial review. Despite the expansive powers granted to legislatures, they operate within the confines set by Constitution. Now, what is confines set by Constitution? Will boundaries, limits Constitution gives, which Constitution gives. In a democratic nation governed by written Constitution, supremacy and sovereignty reside in the Constitution. However, the duty of protecting the rights given under the Constitution falls to the courts through judicial review, making them in the process the ultimate arbiter of constitutional interpretation. Now, this is very important line. The duty of protecting the rights given under the Constitution falls on whom? To courts. Through judicial review. What is the technique through which constitutional rights are safeguarded? Is technique of judicial review, making them in the process the ultimate arbiter of the constitutional interpretation. So, I am on the point first that there has to be a culture of constitutionalism. There is a book, my friends who are studying want to have some academic, academic dive into constitution study. I can make you note one very interesting book authored by Honorable Justice A.K. Sikri. He was one of the judge of the Supreme Court of India and one of the great tax judge in our country. He has written this book. The name of the book is Constitutionalism and the Rule of Law by A.K. Sikri. In the theater of, the title is Constitutionalism and Rule of Law in a Theater of Democracy. Now, it's one of the wonderful books on constitutionalism. How there can be better culture of constitutionalism, how citizens of the country can use constitution, how we as a chartered accountants can use in our constitution in our day-to-day life. That is one important book. And one more book at the outset, I will suggest my viewers to have a look at it. The father of one of the Supreme Court judge and himself a legal eagle of the country, Honorable, although no more, Fali S. Nariman Saab. Fali S. Nariman, he has written a book, friends. You must know your constitution. So two books I have recommended. One is Constitutionalism and the Rule of Law in Theatre of Democracy by Mr. Sikri, Justice Sikri, and one by Fali S. Nariman Saab, You Must Know Your Constitution. So, I was on constitutionalism. What is constitutionalism? What do we understand by constitutionalism? Justice Surya Kant in this Section 6 Citizenship Act order in para 40 has connoted, has enumerated, has delineated three aspects of constitutionalism: written constitution aspect, superior law aspect, and judicial review aspect. Now, let me pose a question to just for make of that what we are understanding from this discussion, that whether there can be a scenario where any authority with whom a chartered accountant is dealing or who is issuing some notices, etc., can say that whatever is whatever are the rights of the particular person are only as per statute, and there are no constitutional rights available to the particular assessee or taxpayer or to the noticee under constitution. The answer is no. Always there is a constitutional guarantee to every person, and that constitutional guarantee, I am using the word constitutional guarantee. Now, this guarantee is not guarantee at the whims and fancies of any particular person or authority. That constitutional guarantee comes automatically to us, sir, and there is inviolable, inalienable. And that constitutional guarantee concept is the part of this today's seminar. That whether the bureaucrats, executive with due respect to them, can snatch the constitutional guarantee to the taxpayers and to the professionals or to anybody or to any citizen of this country at their whims and fancies. The answer is no, 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 no. And if you go to Article 13 of the Indian Constitution, friends, it is clearly stated any act of the government where they make any law, etc., and which is violating constitution provisions, especially this fundamental rights chapter, part 3, then it will be void to that extent. That is Article 13, sub part 2. It clearly says that, and I will read that part, that is being also somewhere noted by Justice Surya Kant in this Section 6 Citizenship Act order, friend. Article 13, part 2 of the Constitution of India. The state shall not make any law which takes away or abridges the rights conferred by this part, that is part 3. And any law made in contravention of this clause to the extent of the contravention be void. The word law in Article 13 का मतलब क्या है? Includes within ambit ordinance, order, bylaw, rule, regulation, notification, custom, usage. So everything almost is included, friends, in this. So having the force of law. So any particular legislation, any particular act of any authority can be checked under constitutional, on the terra firma of constitutional provisions, is the spirit of this Article 13 too also, and is the overall part of constitutional scheme. And I have used the word constitutional guarantee. Constitutional guarantee is given by constitutional provisions where there are some fundamental rights and where there are some constitutional rights. So those rights which are the guarantees to which I use the guarantee as per our holy constitution cannot be snatched by government or executive authorities or regulators at their whims and fancies, and there has to be scrupulous. There has to be very clear following of mandate of constitutional guarantees, especially those guarantees which are part of part 3, that is fundamental rights chapter, where one of the important rights is that they will be following equality, equality norm. Now, I will come to that in a slightly later. Just I was discussing constitutionalism. So constitutionalism, friend, is defined by Supreme Court in this landmark order of Section 6 Citizenship Act. This judgment is an epochal order. Before I close my window on the judgment, all my viewers can note that Section 6 Citizenship Act judgment of 5-judge bench by Supreme Court, especially Justice Surya Kant Saab order, is a epochal order if one has to understand what do we mean by judicial review. I am telling you 360-degree view. What is judicial review? Is one of the classicals judgment, locus classicus. This judgment is locus classicus on what is judicial review. Now, judicial review 360-degree view is given by this Honorable Judge Justice Suryakant Saab, and he has stated from this US this concept has come, and how Indian system has adopted it, and how this judicial review what are the limits to judicial review. But he has said that now there is a particular thing I will just say to make my interaction more practical also, and dealing with some hardcore case studies. Supposingly a law is made which is being discussed at various places, and we see daily on our experience some or the other laws are made by the parliament, friends. And in those laws, sometimes the provisions like section 43 capital B, 43B small h, the disallowance will be made when payments are made to MSME and they are not being they are not paid within a particular defined period. Now that is disallowed. Now there are so many legislations which are made by the government, and as far as chartered accountants are concerned, I would like to submit that when we talk about constitutionalism, sir, and when we talk about judicial review, sir, then judicial review can be done of all the acts. Now, what are the judicial review can be done of? Judicial review can be done of amendment in the constitution, whether it is, and second, any legislation, any lawmaking has to fulfill and satisfy constitutional provisions, which I will delineate slightly later. And third, every act of executive act has also to be in accordance with the constitution. Please note, there are 3 points of judicial review. One, any constitutional amendment will be subject to judicial review. Any legislative act will also be subject to judicial review. And any executive act will also be subject to judicial review. Now, judicial review is to be done by whom? Constitutional courts. Now, constitutional courts are whom? High courts and Supreme Court. Now, High courts and Supreme Court are having the powers under Constitution of India under different articles to check whether these 3 acts, amendment in Constitution, legislative act, and executive act, are in accordance with the Constitution or not. That is the broader constitutional scheme and constitutionalism. So I was talking about, let us say, some notifications is made, some circular is issued, or some act is made and provision is made. Can anybody say that this provision is made, it is okay, it will be treated to be deemed to be constitutionally valid? Sorry, there is no such thing. It will be deemed to be constitutionally valid, and it will be always valid, and it will not be scrutinized. That is the theme of the section 6A judgment of Supreme Court. They have said that every citizen has the right to go to the constitutional court and say to request the constitutional court, please see whether this amendment made by the parliament and the state legislature, whosoever is there, is in accordance with the Constitution of India or not. That is a superior law. So I was talking about section 43 capital B small h. So one can file the writ petition, constitutional validity petition, before the Honorable Constitutional Court, who are the having the power of judicial review under our holy Indian Constitution, and they can go, and they are bound to go. That is what Justice Suryakant has very nicely stated in this case, because there was a objection in this case from the Government of India, Union of India side. This challenge to Section 6A of Citizenship Act should not be entertained because it's a policy matter. It should not come in judicial review. And there is a delay and laches on the part of petitioner to to challenge the validity and vires. Vires, we say, vires means validity of the particular provision of a law. So, but the Supreme Court has if my friends can note this paragraph 75, I will just read. This is the part of that. That whenever a constitutional validity of a provision is challenged, it is the duty of the Constitutional Court having power of judicial review to admit the petition and decide the constitutional validity issue at the threshold itself. Many times we have seen, with due respect to the courts, that they do not entertain the constitutional challenge in the spirit in which it should be, as highlighted by Honorable Justice Suryakant in this 5-judge constitution bench decision of Supreme Court of India. So I have to highlight this particular paragraph 75, that one cannot, if I read this sentence properly, it says, to conclude, while there has been undoubtedly a considerable delay in the instant petitions, I will tell what is the delay. The Government of India was harping upon the point that these petitions are challenging the vires of this provision after a long time. But court says no, doctrine of delay and laches will not come in the way of petitioner to challenge the vires of a provision, because This is so because the present proceedings raise substantial questions that affect public at large and constitutional validity of a statutory provision. Supreme Court says if you were to decide otherwise, we would be, in a sense, creating an artificial deadline for important constitutional issues. This would give to an unfair principle of law in the realm of constitutional adjudication, sir. So I take a pause here. Constitutionalism culture comes when there is a true constitutional adjudication. Now, when there is a true constitutional adjudication, when the courts entertain constitutional issues properly and they decide them. I'm not saying they have to decide that always, that in this case they have upheld the validity of Section 6A. Deciding the issue in the favor of lawmaker and lawgiver is one thing, but admitting the challenge and allowing the citizen and petitioner to contest the validity of a provision being made by a parliament, whether it is competent provision and whether they have competence or not, and whether it is constitutionally fit or not, is a different thing. So Supreme Court in this case has encouraged and given emphasis on proper constitutional adjudication of constitutional issues by the constitutional courts. So there is a lot of constitutional adjudication, constitutional issues, and constitutional courts, and constitutional guarantee also there. So friends, I was just saying there are so many activities in day-to-day there are so many law-making activities which we see in our day-to-day practice. Can we say that all of us should be very vigilant? I humbly submit that whether those law-making activities and lawgiver activities are in accordance with the Constitution of India or not. And we should have a temperament. See, I'm using the phrase temperament. I will just have a suppose please. That this temperament to check the issues from constitutional angle is a very important point. You will say, Mr. Goyal, why you are using this word temperament? Because to accept everything coming from the lawmaker, lawgiver, that it is okay, it is acceptable, it is constitutionally fit, it is always right, is not as per our constitutional scheme, is not as per our constitutional theme, is not as per our constitutional goal, is not as per our constitutional scheme of the things. So we have to have a constitutional temperament, that we have to pursue our submissions, arguments, pleadings in the constitutional tone. Now, if I have to say myself, I have to present myself, I will first try to submit myself in a constitutional tone. Now, what is constitutional tone and constitutional temperament? That I will make myself, my argument, my submission better presented when I use these constitutional provisions, which gives me various constitutional guarantees, and which are the main safeguard against the arbitrary exercise of power by various regulators. So friends, this is all about the constitutionalism. Justice Suryakant order, Section 6A Citizenship Act have been noted, I hope, by all of you, and you have understood what is constitutionalism and what is the theme of constitutional adjudication, and how constitutional courts have been given this very important power and very unique power of judicial review. Now, judicial review, I come to judicial review. You know, when as a chartered accountant, I qualified, sir, and I have learned whatever in my life mainly through my CA friends and through my chartered accountant community. Maybe now I'm practicing lawyer, but that is due to the fact that I have to appear in courts. But I'm due to my CA friends and CA fraternity. I will tell you, we as a chartered accountant sometimes felt that whatever regulator is doing, sir, it can be only challenged in appeals and all these statutory appeals. I'm telling you, sir, there are two types of remedies. One is statutory remedies, sir, and one is constitutional remedies, sir. My topic of today is to emphasize to all my great friends that we have to also have knowledge of constitutional remedies. What is constitutional remedies? Constitutional remedies are contained in various provisions of Constitution of India, where a particular person, aggrieved person, who is aggrieved by an action of an executive or any authority, can approach the constitutional court and ask for the remedy and ask for the relief, appropriate suitable relief. Now, what are those constitutional remedies? Constitutional remedies, I submitted that it is contained in various parts of Constitution of India. Two are very important. Three, Article 32. You know, Article 32, Dr. B.R. Ambedkar says that this is one such provision without which entire constitution shall be a nullity. Dr. B.R. Ambedkar Saab, when constitution was made, clearly spelled out that without Article 32, Constitution of India is zero. Now, what is this in Article 32? Article 32 gives special and unique power to the highest court of our country, highest court, Honorable Supreme Court, to directly entertain any petition from any citizen where there is a violation of the fundamental rights contained in Part 3. So Article 32, Article 32 is the lifeline of Constitution per Justice B.R. Ambedkar. Justice B.R. Gavari Sahab also in some of the lecture has emphasized on this. So Article 32 is a constitutional remedy provision, friend, which gives the power to the Honorable Supreme Court, the Summit Court, the Apex Court, to entertain directly a petition from an aggrieved person, citizen, where there is a violation of fundamental rights as contained in Part 3 of the Constitution of Holy Constitution of India. Article 32 is one remedy. What is another remedy? Article 136, special leave petitions. You know, various cases, the case goes to Supreme Court through High Courts. Then Article 136, that is the special leave petition provision is used. That is a constitutional remedy. That is not in any act. SLP, special leave petition, is contained in Article 136, Article 136. Now, this is also a very wide power given to the Honorable Supreme Court to see that the various authorities remain in the confines of Constitution and their powers. They don't misuse, abuse their powers flagrantly. Article 136 is a repository of a special powers given to the Honorable Apex Court, where the constitutional remedies of special leave petition, SLP. So Article 32, direct petition. Article 136, SLP from various orders of High Courts, etc. And Article 226, I say this is the most important constitutional remedy, friends. Article 226 and 227 is what? Power given to the Honorable High Courts, wide our Indian Constitution, which gives them the power, discretionary power. Now see, Article 32 is the power to Supreme Court for fundamental right violation, direct petition. Article 136 is the power to Honorable Supreme Court for special leave petition. Now, Article 226 and 227 is the writ power, writ, W-R-I-T, writ petition to the Honorable High Court, where a person agreed can approach the Honorable High Court, that is the Territorial Judicial High Court, where he is assessee or where his case is assessed, where his jurisdiction falls, his Judicial High Court, and he can request the Honorable High Court in his. Now, this Article 226 and 227 gives discretionary powers. This is discretion to the High Court to entertain any writ petition. Now, there are 5 types of writ petitions, friends, which are stated in Article 226. If I recapitulate, many of you are aware. One is writ of mandamus. Second is writ of certiorari. Third is writ of habeas corpus. Fourth is writ of quo warranto. And fifth is writ of prohibition. There are 5 writs. I repeat. Writ of mandamus. Second, writ of certiorari. These are the 2 most important writs for chartered accountants and commercial litigation and this tax law litigation. Article 226, writ of mandamus and writ of certiorari. I will say what is. I will just state what is. Article this 226, first writ of mandamus, writ of certiorari, then writ of habeas corpus, then fourth is the writ of this quo warranto, and last is writ of prohibition. Now, these 5 types of writs under Article 226, friends. What is this provision about? And I'm telling you, in my respectful submission, and Mr. Nariman also, Falias Nariman, I was saying all of you to read this book. And in his book, he has very beautifully stated about this Article 226, the chapter of Article 226 in the book of Mr. Nariman. You must know your constitution is classically stated that although Ambedkar Sahab stated Article 32 is one of the lifeline, I humbly submit as today's perspective, Article 226 is the most important lifeline of the Constitution. Because every person directly goes to Supreme Court, and Supreme Court generally now says that please come through High Court. And High Court has the power to entertain writ petition under Article 226, friends. So most important current perspective provision where the taxpayer, where the aggrieved person, where the person who is meted injustice can go to a legal clinic, litigant can go to a legal clinic for his injury treatment is the Article 226 remedy and constitutional remedy of Article 226. That is the writ petition. Now, 5 types of writ petition I said. Now, these 5 types of writ petition, Mr. Nariman says, are the Article 226 in his word is a searchlight provision. Searchlight, आप समझते हैं? Searchlight means which is the most powerful provision giving justice to the people of the country. If you go to any high court website and have its cause list and see how many matters are appeals and how many matters are writ petitions, one can find out from the cause list of the various high courts for himself that majority of the cases are under writ petitions. Why? Because that is the remedy which is, what do you say, convenient or easy and speedy remedy. When we know we have to go through rigmarole of appeals remedies, then the justice is not quick. Justice is not timely. Justice is not expeditious and speedy. So Article 226 gives us speedy, expeditious and timely justice by High Court honorable judges of honorable High Court. But with due respect to various High Court judges, I have seen in the current time the spirit in which this Article 226 out to be used is not used, friends. Article 226 cannot be used like this, that majority of the cases are to be thrown out of Article 226 because it's a discretionary remedy and it is the discretion of the High Court to admit or not. With due respect, this is a discretionary remedy, yes. But that discretion has to be used in what manner? Can it be said that 90% of the people who come to High Court for writ petition for the injustice meted out to them, they can be said, no, we will not give you justice here. Go to clinic of statutory appeals and take the justice here there. Your injury will be treated by statutory appellate authorities. This is wrong. In words of Justice Krishna Dixit Sahab, Karnataka High Court judge, Article 226 should not be remedy, should not be like this, that there is an alternate remedy, there is a statutory remedy, go there. As if it is like that, if an injured person is coming to a legal clinic for his treatment, a judge says, no, your treatment will not happen in this Article 226. You get your treatment done in statutory remedy. What is this? Is it in the constitutional spirit? Is it in the constitutionalism sense? Is it in the constitutional culture? Is it in the constitutional scheme of the things? So one should answer that. And it is in the constitution sense, as Mr. Nariman said, that this provision is a searchlight provision. So honorable High Court judges should encourage that people may get relief in the High Courts, in the writ petitions in a larger manner, in the broader manner, and in the wider manner. Not in the narrower manner, in the restrictive manner, nor in the discouraging manner. I have seen, with due respect, various honorable High Court judges at this time in various High Courts are not entertaining writ petitions on the ground of alternate remedy and just dismissing in limine the writ petition and not granting discretionary relief just because that assessee can or taxpayer or particular person has to go to statutory authority. This is wrong, to my respectful, all humility, personal opinion. I will just make my present submission good with another angle, that why Article 226 should be encouraged in a wider sense. Because when we see mass injustice happening at the end of various statutory authorities with due respect to revenue authorities, and when we see thousands of 148 reopening notices, thousands of GST show cause notices, thousands of notices comes in thousands, bulk, can the taxpayers be asked, go, wait for appeal, pay the demand and be happy? This is the way the justice can come to the taxpayers. This is the way the constitutional rule of law can be maintained. This is where judicial review provisions can be given sanctification. This is where constitutional things can work. This is where we can respect and can say we are a country, we are having constitution and we are respecting constitution. So we should introspect that how far Article 226 is being healthily used in the manner in which constitutional framers have made it. So this discretionary remedy of Article 226 of 5 types of writ petitions should be encouraged and regarded in a proper manner, not discouraged in a restrictive and a narrower manner, in a pedantic sense. Now, if this culture goes, now I will just like to tell you, my friends, that there have been various cases in the country, not taxpayer or chartered accountant. You have seen some people, and with due respect to the government, where bulldozer justice. Now, you know what is bulldozer justice? Bulldozer coming to the house of a person who is treated as an accused according to a bureaucrat and his house is bulldozed. That is called as bulldozer justice. Now, Supreme Court of India, Honorable Supreme Court of India, in a landmark ruling written by Honorable Justice B.R. Gavai Sahab, in the case of this bulldozer justice, has stated that this concept of bulldozer justice is totally antithetical to rule of law. I have said Article 226. I have said constitutional remedies. 3 constitutional remedies I have highlighted. Article 32, Article 136, and Article 226. Article 226, I stated that Honorable Nariman Saab stated it's a searchlight provision. It has to be encouraged. 5 type of writ petitions we understood: habeas corpus, prohibition, certiorari, mandamus, and this quo warranto. 5 types of writs. 2 writs are most important in our today's writ petitions are most important. That is writ of certiorari and writ of mandamus. Writ of certiorari and mandamus are the writs which allow high courts, or which permit high courts, honorable high courts, or which give power to the high courts to sensitize, to interdict, to intervene in the act of an authority which is arbitrary, which is violating the statutory provisions, which is absolutely what you say, irrational, etc., unreasonable. So this power of judicial review is one thing. Constitutional remedy concept is another thing. 3 remedies, Article 32, 136 and 226 is another thing. Article 226 and 227, writ petition power to the high courts is very important. And in that, writ of mandamus and writ of certiorari. Please note. Writ of mandamus ka matlab means, mandamus means high court can direct a statutory authority, give a command ki please give the refund, please give the amount due to the assessee, please issue the refund, please do this act as per law, please do your duty, please don't shirk from your duties. That is writ of mandamus. And writ of certiorari, if there is a violation of a statutory provision by any statutory authority, they breach their Maryada or Lakshman Rekha as per statute, then High Court under writ of certiorari can sensitize it. So please be careful, be alert, and have a constitutional tone and temperament that writ of certiorari and writ of mandamus can be used in various variety and maze situations to control the executive anarchy at various places. I'm using the word anarchy with due respect. There has been executive anarchy in various tax provisions like section 148 with due respect. I have never seen in my career of 20 years that a statutory authority misusing 148 like this kind. And what kind of 148? What kind of information? Now you say, see, if with this article 226 would not have been there, friends, and if article writ of this certiorari in mandamus would not have been there, I don't know what life of Indian citizens would have been. When the technology now in the Income Tax Act, in the other laws, the government says or the authority says, no, system is bigger than the law. We will act by system. Law goes haywire. Now see, I say in various seminars, who is the bada? Who is the bada? Like Ganeshji, Lord Ganeshji in this all, sabse bada, all Ganeshji San in the law is Constitution Sahab, then law, then rules, regulations, and then circular notification, and at the end system. 5th place. First constitution, then law, then rules, regulation, then circular notification, then the system and portal. What is happening? Various places, CPC and system, income tax law I'm talking about because I do income tax. They are saying that something wrongly feed into the system, software, technology, AI. Software will be bigger and law and constitution, everything will be lesser. How is this possible? And Supreme Court of India, speaking through Justice P.S. Narasimhan, in a landmark case of Sunil Bhagat, in the asking CBDT to see that software acts as per law. Not act has to work as per the software, not technology. Please, interplay between technology and law. So what is this happening? That technology is bigger or law is bigger? And taxpayers have to go to the High Courts and Supreme Court under Article 226 and 136 to request High Court ki sahab, please say to the Income Tax Authority, they make their software as per the provisions of the law. Not technology, law has to be changed as per the technology, please. And I'm sorry, saying in this sense, there are 4 honorable High Courts, Madhya Pradesh High Court, Gujarat High Court, various other High Courts, even Delhi High Court and other High Courts, Bombay High Court, Justice M.S. Sonak in Larsen and Toubro case, in a matter of DGFT. Foreign trade. He says that if you are in an era of artificial technology, can there be a scenario where technology and software prevail over the law and legislation and the constitution? I leave it at you. So Article 226 is a very important constitutional remedy. It is one of the important practical lifeline today, friends. It has to be understood by the my lords of Honorable High Courts in that constitutional tone and spirit, and Honorable Supreme Court in one of the landmark order. There are various decisions. There is there are thousands of decisions of Article 226, but I will tell you one very important order. Godrej Sara Lee Limited versus Commissioner Central Excise and Taxation Officer. This order of Godrej Sara Lee Limited is authored by Honorable Justice Dipankar Datta Sahab of Honorable Supreme Court along with Justice Bhatt as his lordship then. Now in this case, there was a Punjab VAT law matter, some Punjab tax law matter, and the High Court refused to entertain Article 226 saying that please go to alternate statutory remedy, appeal, etc. under the statute, relevant law. The Supreme Court overturned the order of the High Court. There was a revision done by the Punjab Vet Authority. Revision is done by the commissioner of that authority. And that revision was totally without jurisdiction. Now, High Court speaking through Justice, Supreme Court speaking through Justice Dipankar Datta Sahab in Godrej Sarali, thousands of orders, friends, of various High Courts have come where this Godrej Sarali has been cited and navigated and analyzed. And I believe in writ petition point, this Godrej Sarali has been an epochal order and is a path-breaking order and is a milestone order where the Justice Dipankar Datta has given a very simple test. You have to, Honorable High Court cannot simply dismiss the writ petition saying that it is not maintainable because there is an alternate remedy. Sorry, that is Supreme Court says no. It has to be seen that if there is a pure question of law or a question of law being raised in the writ petition, which is based on admitted and undisputed facts. There are two things: question of law raised on admitted facts, undisputed facts. Then writ has to be entertained, even though there is an alternate remedy. The test is question of law based on undisputed and admitted facts. Then the writ petition has to be admitted without relegating the petitioner to the alternate remedy. So, Godrej Sarali Limited versus this excise taxation officer, order of Justice Dipankar Datta Sahab, Supreme Court of India, on Article 226 bandwidth and scope is a landmark order which you all should note. And various income tax and High Court cases, we generally cite this order, and this is a beautiful order. I will tell you one more judgment. Honorable Supreme Court of India, in speaking through Justice Chandrachud Sahab, in an income tax matter in case of Union of India versus Rajiv Bansal, 469 ITR, page number 446, where thousands of 140 notices were subject matter of issue. 469 ITR, page number 46, Union of India, Rajiv Bansal. Author of the judgment is Dr. D.Y. Chandrachud, the former Chief Justice of our country. His Lordship, speaking through Chief Justice, past Chief Justice, has very succinctly and lucidly stated in one of the paragraphs that issue of jurisdiction can always be raised between the high courts. So, issue of jurisdiction has to be taken up at the threshold. It can't be said, no, we will not check jurisdiction first. We will first say, please come. Somebody has sent me something. Ma'am, somebody has sent something. Sonia ji, what a question. Good, very beautiful question she has asked. She has said, which profession you see? I will answer it in my tone. Let me have it in my tone. Just a moment. Ma'am, what is happening is, see, I tell, because now I'm not on physical mode. But when I am there, I told in the beginning also, maybe Sonia ji has missed. Sonia ji, I say I'm a small man, but I say with all due reverence that if Lord Krishna, who is behind me, Upar, asked me that Mr. Goyal, in the next human life, what you would like to become? I would say, Prabhu, I would like to become chartered accountant in my life. Because today, whatever respect I am enjoying with myself is due to chartered accountants. This is, I have told you in the beginning, advocacy profession I am to do by, what do you say, it's no choice. If I have to go to High Court and Supreme Court, I have to have advocacy practice. But my DNA, my Atma, my soul is CA only. Anyhow, that's, I hope this answers your sweet intervening question. And somebody else who has this kind of question for me, I definitely enjoy this kind of things. Rather, I love that people ask me these things. So what we were discussing? We were discussing Godrej Sarali Limited, Honorable Supreme Court of India, Justice Dipankar Datta Sahab order on maintainability of the writ petition. There is a test given by Justice Dipankar Datta Sahab that writ petition will be maintained against any action of an executive authority, tax authority, where there is a question of law being raised and it is based on undisputed and admitted facts. So temperament should not be to dismiss the writ petitions. Like limitation, I have told Rajiv Bansal order also of Justice Chandrachud Sahab. One can read that. And judicial question, now very important is that I don't know how many chartered accountants of us who are understanding what is the serious significance of a jurisdictional fact and jurisdictional issue and jurisdictional question. 3 words: jurisdictional fact, jurisdictional issue, and jurisdictional question. All these can be taken directly in the constitutional remedy via Article 226. Jurisdictional issue, jurisdictional question, and jurisdictional fact. Now, what is jurisdictional things? All these jurisdictional things. Jurisdictional thing is this, sir. If jurisdiction things, authority, power of an authority to enter into that area. Now, if there is no authority, power of an authority to enter into the area under the law, then there is a jurisdictional issue, sir. And jurisdictional issue, what means? Jurisdictional issue means the issue which goes to the root of the matter. It has to be decided upfront at the inception, at the beginning of the proceedings. Jurisdictional question cannot be staggered and cannot be postponed, cannot be deferred, cannot be said that it will be done at the Ganga Sagar stage. It has to be done at the Gangotri stage. So jurisdictional question, jurisdictional point, jurisdictional issue. So as a chartered accountant, as a consultant, tax consultant, our temperament should be that we raise jurisdictional question at upfront before the authority and ask them to first decide our preliminary jurisdictional issues, and then if they are deciding those jurisdictional issues against us, then you can go to the Honorable High Court under the writ petition power under Article 226, writ of mandamus and writ of certiorari. So I have discussed something regarding constitutional remedies, friends. Now I would just take up one more area. I was talking about Justice B.R. Gavai's order, and I'm telling you, all of you can please have this judgment on your screen and just have a look at it, what a judgment it is. I believe some very few judges write judgments like in this, what do you say, larger heart and things. Now, this is one of the judgment where Supreme Court of India, Justice B.R. Gavai's order, and the case title is this: Directions in the matter of demolition of structure. It's not income tax law order. Earlier, I saw Section 6 says order of citizenship act. Now, this is bulldozer justice wala judgment of Supreme Court. The citation is neutral citation 2024 INSE 866. Now, this judgment by Justice B.R. Gavai is very landmark order on rule of law and accountability thing. You know, as a chartered accountant, many times it comes to our heart and mind that why not accountability of the errant tax officials is being fixed. But this judgment brings the point to the focus that as a constitutional culture, there has to be rule of law first, and then there has to be a accountability culture also. With due respect, na to abhi I have never seen, with due respect to the regulators in the income tax authorities or tax authorities, that there is a proper culture of accountability. On paper, it is there, maybe there, but on ground and real sense, it is not there. So these words of Justice Gavai, where the issue was that people whose houses are bulldozed by authorities in name of justice, can it be called as a justice? Can it be called as a part of rule of law? Now, what is rule of law first? Is this rule of law something to do with chartered accountants and a citizen? Yes. Without rule of law, our entire constitution is focused on rule of law, friends. Without rule of law, there is no constitutional thing. So Justice B.R. Gavai has given 360-degree view of what is rule of law vis-a-vis constitution in Indian jurisprudence. Now, it's not a theoretical sermon or it is not a theoretical hyperbole. It is a very serious statement and very serious view of a very senior judge of the Supreme Court, number 2, B.R. Gavai. After Khanna Saab, he's the second judge, senior, and he may become he's to be the Chief Justice of the country next. So B.R. Gavai Saab, the rule of law views on Justice Gavai. The rule of law has been succinctly conceptualized by Dicey, which can be summarized into 3 postulates. Now, Dicey Saab has been like Tulsi Das for rule of law. So Dicey has always stated what is rule of law, and rule of law is not equal only for criminal or some jurisprudence. Rule of law for tax jurisprudence also. Rule of law for bureaucrats in the income tax also. Executive in the income tax also. This rule of law does not distinguish between tax authorities and other authorities. And with due respect, tax authorities many times feels that rule of law does not apply to them. With due respect, it is wrong. No man is, what is the rule of law? Conceptualized in 3 postulates by Mr. Dicey, as stated by Supreme Court. 1, no man is punishable or can be lawfully made to suffer in body or goods, except for a distinct breach of law established in the ordinary legal manner, established in the legal manner before the courts of land, as contrasted to the exercise by persons in authority of wide discretionary arbitrary powers of constraint. So there has to be a punishment or something, confiscation, seizure, demand, tax demand done by some proper manner in the proper legal way. No man is above the law is the second point. Every man whatsoever be the wrong. There is rule of law, second postulate. Third postulate is the predominance of legal spirit. That is, greatest principles of the constitution are with us the result of judicial decisions determining the rights of private persons in particular cases before the court. The predominance of legal spirit is the third part, very important part. Now, this legal spirit, as I have already said, I will give for example that when rule of law is diminished, or when rule of law is goes or is breached, when there is a mass arbitrary use of when there is a serious arbitrariness in the acts of the authorities, when there is serious breach of the constitutional norms, healthy norms, when there is a total unfairness, and where there are whimsical and irrational and ad hoc reactions, or impulsive actions of the authorities. So rule of law cannot be jeopardized in any manner by anybody. And if somebody makes rule of law goes, that is what Justice Gavai says, his accountability should be fixed there. So this judgment I am not showing you for theoretical sense. Other judgment of section 6A, that's a landmark order of Justice Suryakant, that all citizens have right to challenge the constitutional validity of a provision. And this judgment is a landmark judgment of Justice Gavai, that rule of law cannot be sacrificed or cannot be compromised in our jurisprudence. Unfortunately, in practical, if you test this judgment in the light of practical scenario today, when we see lot of show cause notices, lot of reopenings, lot of past concluded assessments being reopened, lot of arbitrary notices, stereotype, rubber stamp notices coming out, where there is no application of mind, that is against rule of law. So, there is a correlation between the requirement of application of mind and the rule of law. When there is no application of mind, then there is no rule of law. And I'm telling you with all sincerity at my command and humility at my command, in various tax authorities notices, there is tax authorities orders, there is no application of mind. This is not I'm saying. This is various high courts and courts, constitutional courts have said in their judicial review judgments of writ petitions that various orders are there where there is ex facie total lack of application of mind on all part of authorities, be it faceless authorities, or be it the jurisdictional authorities, or be it the sanctioning authorities. So one has two very serious importance. What is rule of law? Rule of law means application of mind. Rule of law means proper exercise of power for the proper purposes. Rule of law means not using the power just to harass somebody and you pressurize somebody. Rule of law means that you don't come to search a person under law, tax law, just for sake of pleasure and entertainment. Roving inquiries and fishing inquiries should not be done. All these are facets of rule of law. Anyhow, Justice B.R. Gavai order, you should also note this is the second important order of today's seminar on constitutional, my point. One was Suryakant Sahab and one is this. Now, I was discussing, friends, that we have to have constitutional temper and rule of law cannot be. Judicial review I have submitted. Judicial review done under constitutional remedies. It is different from statutory appellate mechanism. Judicial review gives you a higher citizen, a higher place to check the act of an authority as per constitutional remedies. Judicial review, you underline, very important. Today's point, rule of law. Rule of law means I have to be ruled by law. Rule of law should be there, not ruled by man, ruled by executive, ruled by bureaucracy, ruled by the whims and fancies. No, there is no such rule of law in our constitution, sir. Supreme Court says, Constitution of India says, entire constitutional, scheme of provision says that there has to be rule of law, certainty, predictability, consistency, non-discriminatory approach. All these are part of rule of natural justice. Without natural justice, there can be no rule of law, sir. Natural justice is part of rule of law. Non-arbitrariness is rule of law. Being reasonable is a part of rule of law. So reasonableness, non-arbitrariness, acting as per the mandate and the spirit of the law is the natural justice, is part of rule of law. When I see various quasi-judicial authorities, with all due respect at my command, like tribunals, not doing justice as per rule of law, it hurts us. So there has to be, friends, proper rule of law, and rule of law not for theoretical sermon, not for theoretical jargon, not for just sake of saying. We have to have rule of law in real sense. And as a chartered accountant, you can say, Mr. Goel, if you have to draft a reply, how can we use rule of law? You can always submit that if there has to be a proper adjudication, there has to be a proper assessment, there has to be a proper determination, there has to be a proper proceedings, then fair trial, all these things as per principle of rules of law, fairness as per rule of law, fairness, natural justice as per rule of law, non-arbitrariness as per rule of law, reasonableness as per rule of law, application of mind as per rule of law. Application of mind, please emphasize. Application of mind means you have to be careful and concerned about what is the facts of my case, what are the particular situation in which you are using your power. So judicial review and rule of law I have touched. I want to touch the third area, general area, then I will come to constitutional provisions, select constitutional provisions. Now, arbitrariness, friends. I have seen one area in constitutional jurisprudence that arbitrariness is very important, friends. You know what is arbitrariness? I have written a paper somewhere where I was just penning down my thoughts that what is arbitrariness and how can chartered accountants and taxpayers in our day-to-day practice we can use arbitrariness doctrine to attack or what you say assail or challenge the validity of various actions. Now, arbitrariness doctrine can be used to challenge even the amendments of legislative exercise, and even arbitrariness doctrine can be used to challenge the executive action. I divide in two parts. Arbitrariness can be used to challenge the constitutional validity of a statutory provision also, and arbitrariness can also be used to challenge the validity of a statutory provision or this validity of a statutory authority, act of statutory authority also. What is the difference between the two? Intensity. When you challenge the constitutional validity of a provision, presumption is there in the favor of the parliament and the legislature that they will make constitutional provision. But the Supreme Court of India, in a series of decisions after Shaira Banu's triple talaq case, has evolved this doctrine, taken this doctrine to the next level, that even constitutional provisions and the statutory provisions and even the law provisions, legislation can be challenged that it is manifestly arbitrary. So it arbitrary ke aage word aa gaya manifestly arbitrary. If it is there, it has to be proved by the challenger, the petitioner, before the court, constitutional court, that you can challenge the constitutional validity of a statutory provision if it is manifestly arbitrary. The leading law on this subject is Shaira Banu's case. Then it has been later very seriously analyzed by Supreme Court of India in 5-judge bench decision of electoral bonds by Dr. Chandrachud. It's a famous judgment of electoral bonds where the Supreme Court has said again, reiterated that yes, manifest arbitrariness test is an important test under Article 14 of the Constitution. Now, where it comes from? Very important. Mr. Goel, where it is coming from, this arbitrariness? I am telling my friends, the Janani, the mother womb, the place from where it is getting birth is Article 14. Article 14 of Constitution of India. What it says? Article 14 says that state shall not deny to any person equality before the law and equal protection of the laws. That is called as Equality Protection Clause. It is contained in Article 14. Now, this Equality Protection Clause or Equality Guarantee under Article 14, which is a fundamental right chapter, Article 14, Equality Protection Clause contains, Supreme Court has interpreted in Article 14 that it is a protection against any arbitrary action. You will say, Mr. Goel, how arbitrariness thing has been read into Article 14. There is a rich wealth of judgments. I am not boring you with that. But in crux and nutshell, in brief, in succinct sense, in very short sense, I'm telling you, there is literature that how arbitrariness doctrine has been evolved from Article 14 mother womb. I am submitting in brief to you that the logic and idea of this, that anything which is arbitrary cannot satisfy the clause Article 14 equality clause. I repeat, anything which is arbitrary cannot satisfy the test of equality clause. Now, what is arbitrary and how it is antithetical to equality is to be understood by you. Something which is done irrationally, something which is done capriciously, something which is done without any principle, without any guideline is arbitrary. Now, there are various legislations or various legislative acts many times where the provision which is being made, it is per se arbitrary. So Supreme Court of India in triple talaq case of Shaira Banu and later on in electoral bonds case and after that also in some more decisions has time and again state that by Article 14 of Constitution of India, a person can challenge the constitutional validity of a legal provision like in section 6 Surya Kant Sahab order which I was reading. There is a very good literature on aapko milega. You will read section 6 judgment, Supreme Court. How you can use this arbitrariness and arbitrariness doctrine in this challenge of Article 14 and in this challenge of Equality Protection Clause and in this all this constitutional challenge. But I am telling you, I can give you a practical illustration that Article 14 has a very serious role today. And this arbitrariness doctrine, I'm telling you, friends, is a very serious point, sir. Various statutory provisions with due respect to the lawmaker and lawgiver and various statutory acts are apparently ex officio arbitrary, sir. You know, Article 14, I have told you, is the mother worm where from which this article, this arbitrariness doctrine has been come up. And one of the greatest proponent, legal proponent of this doctrine has been Justice Bhagwati Saab. Justice P.N. Bhagwati, if somebody is interested, he can read. Justice P.N. Bhagwati in various Supreme Court orders has taken the concept of arbitrariness to the next level. In Menka Gandhi case, one is the Menka Gandhi's case of passport case, famous case, and E.P. Royappa's case. There are 2-3 judgments one can note down. E.P. Royappa. Second is this, I telling Menka Gandhi, and third is Ajay Hasia. All these decisions of Supreme Court by Justice P.N. Bhagwati. P.N. Bhagwati has been the Supreme Court judge and Chief Justice of our country. A great judge, a great proponent, what you say, protagonist of arbitrariness doctrine. His lordship has stated in his various decisions, which are today giving us something very important to fight before the courts, that if any act of any authority, if any act of a parliament, if any act of the lawmaker, legislature is arbitrary, friends, you can use it as a separate ground. Wide Article 14, wide Article 14. Judgments, Menka Gandhi case, passport case, judgment E.P. Royappa's case, judgment Ajay Hasia, and judgment International Airport Authority Ramana Shetty case. 4 decisions of Justice Bhagwati. Ramana Shetty, Ajay Hasia, and third is E.P. Royappa, and fourth Menka Gandhi. All these 4 judgments combined together, arbitrariness doctrine is completely adumbrated. So why I'm telling you is arbitrariness is very important aspect of today's challenge. Even if we file an appeal before an appellate authority, even if we challenge any writ petition, any judgment or a notice, then arbitrariness cannot be taken lightly. Supreme Court, a judge is there who has been a senior lawyer, now he's a judge, Justice Narasimhan Saab. Friends, he has written a very important order, this Justice P.S. Narasimhan Saab, in Supreme Court of India. The name of the case is, you can note down, Manoj Kumar versus Union of India. It's a 2024 order. Manoj Kumar versus Union of India. Supreme Court Justice Narasimha says, wherever there is a challenge by any person or citizen of any statutory authority decision on the ground of arbitrariness, it is the duty of the Constitutional Court to take that challenge up front and decide it, and nip the bud approach should be there. If there is any arbitrariness in the decision making of any authority, it should be taken in the nip in the bud approach. I have cited the decision of Manoj Kumar of Union versus Union of India by Justice P.S. Narasimhan Saab, that arbitrariness challenge is a very important challenge. And there are various facets. If I am to tell you, Mr. Goel, how we can elaborate our challenge on arbitrariness doctrine and Article 14 aspect, I am just highlighting, friends, 5-6 points you can note down. One is, something which is arbitrary is without application of mind. So when you say there is non-application of mind, it is automatically arbitrary. One facet of arbitrariness aspect is non-application of mind. One aspect. And this is writ large, ex officio, apparent in thousands of notices which the departments issues, in tax department issues. So non-application of mind is one part. Second, how you say there is arbitrariness? The power is used for collateral purposes. There is a, what you say, you say fraud on the power or a legal malice. Arbitrariness ka ek facet hai legal malice. When there is a malicious use of a power, malicious means the power is used for the purpose other than the purpose which is given in the law. That is fraud on the power. That is colorable exercise of power. That is legal malice, malicious use of power. So one aspect of arbitrariness is non-application of mind. Second aspect of arbitrariness is that this being power is used for other purposes, illegal, unlawful purposes, or the purposes other than the purpose for which it is given. That is, we say as legal malice. Third part of non-application of mind, friend, is the fairness aspect. Whether the authority who is acting is fair or not. acting as per principle of fairness. That is, what is principle of fairness? Principle of fairness means they are giving you the relied upon material, they are giving you cross examination, they are giving you the back material gathered against you. That is fairness. They are giving you proper time to reply, they are giving you proper oral hearing and virtual hearing. So all these things are part of doctrine of fairness. So arbitrariness के अंदर आया non application of mind, arbitrariness के अंदर आया second point legal malice, arbitrariness के अंदर आया this fairness, third point. Arbitrariness, fourth point, that decision making process which is being conducted now, decision making process means the entire decision making process which is being done by the tax authority or a particular authority is in accordance with the proper norms, prescribed norms. For example, there are circulars and instructions which says that in this manner the authority will act. Or for example, there has to be proper decision making process, step by step approach. So decision making process is done in a proper manner is one of the part of arbitrariness doctrine. Supreme Court, speaking through Justice J.B. Padiwala Sahab, has highlighted that arbitrariness doctrine has serious role to analyze whether a particular decision making process of a particular authority is in accordance with the law and constitution of India and Article 14 and Article this arbitrariness parts. So one part of arbitrariness, fifth part is that the higher the the more wider the power, the more lethal the power, the more draconian the power, the more reasonable manner it will be. Reasonableness of the power, reasonableness aspect. So arbitrariness has reasonableness aspect also. So I have coined down five points to you: reasonableness aspect, fairness aspect, legal malicious aspect, decision making process aspect, and non-application of mind. So arbitrariness, this is the 5 bullet points you have all noted, I hope. And arbitrariness challenge is one of the very, 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 very important challenge in the constitutional aspects, be it of the legislative lawmaking and be it of the statutory authority. Arbitrariness aspect is one of the very important aspect of judicial review and these constitutional remedies. So now I take you through in this another leg of my this thing. Now we come to what are the various important constitutional provisions, friends. Let us start with the beginning where the preamble was there. I said you preamble to the Holy Constitution says that we the people of India. If I'm to show you this red book, now this you all are familiar and you have seen it TV many times. So we all, but I am not telling you for any purpose, but I am to read the preamble to you. What is the preamble to our Holy Indian Constitution? It's a very important thing. The preamble means in introductory part, what is this is, we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to its all citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity and to promote among them all, fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Now, 4 aspects of preamble. One is justice, liberty, equality, fraternity. We the people of India. So this is the opening statement in the preamble to our Holy Constitution. And it itself gives the message that how Constitution of India should be taken up. It is the superior law. It is the ground norm. It is the highest law. It is the law by which all other laws are tested. So Constitution is the supreme law, friends. So I was to now take you to, in a chronological order, what are the various important, widely impacting provisions from chartered accountants' perspective. I have already told you in narrative that what is constitutional narrative in our landscape, jurisprudential landscape. As far as fundamental rights are concerned, sir, they are contained in part 3. And part 3 starts with one article 12. Now, what does that article 12 says? This says in this part, unless the context otherwise requires, the state includes government, Parliament of India, government and legislature of each states, local authorities or other authorities within the now ye state ka paribhasha, the definition of state under article 12 is why important, because you can challenge the action of the state by this article. What is a state for the constitution is defined in article 12. It is a very wide definition. Any instrumentality of state, any statutory authority are part of state under Article 12. So you can challenge the actions of state which are defined under Article 12 under constitutional remedies and judicial review, etc. So it's very important. Article 12, the definition of state. Now, what does Article 13 says? Very important. Very, very, very important. It is again part of Part 3 of Constitution of India. What is Part 3? Part 3 is a chapter where fundamental rights are there. Fundamental rights are that they are given by Constitution. They cannot be waived. They cannot be snatched by government at their whims and fancy state. So Article 12 was one I read, definition of state. Article 13 now. Laws inconsistent with or in derogation of fundamental rights. This is the heading of Article 13, friends. I repeat. Laws inconsistent with or in derogation of fundamental rights. Why are you saying, Mr. Goyal, emphasizing on this? I'm telling you, sir. Article 13 marginal note heading is very important. I repeat third time. Laws inconsistent with in derogation of fundamental rights. So any law which is made in derogation of or which is with the derogation of is to be void. I read it. Article 13, sub-article 1. All laws in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent, जो पहले से बना हुआ था, पहले से मतलब which was earlier there prior to constitution will be void if it is in derogation of this part 3. Article 13(2) is very important, which Justice Surya Kant Saab has reproduced in the Citizenship Act judgment. It says that the state shall not make any law which takes away or abridges the rights conferred by this part. I repeat this part. There are Article 13, sub-article 2, two parts. Very, very important, two parts. The state kaun hai? It is defined in Article 12. Note, state is defined in Article 12. All state authorities, all instrumentalities of state. The state shall not make, shall means mandatory, shall. The state shall not make means nahi banayega. The state shall not make any law. Law is defined later on. The state shall not make any law which takes away or abridges the rights conferred by this part. This part means part 3. The state shall not make any law which takes away or abridges any right, abridges the rights conferred by this part. The second part of Article 32 says, any law made in contravention of this clause. अगर कोई भी कानून बनता है जो इसके खिलाफ है, any law made in contravention of this clause shall to the extent of the contravention, जितना contravention है be हुआ. अब आपको आर्टिकल 13(2) से क्या समझ में आया? What do you understand by Article 13? Article 13(2) says कि any law which is being made in derogation of this fundamental rights chapter, it will be void to that extent. What is state? Defined in Article 12. What is law? Law includes ordinance, law includes order, law includes bylaw, law includes rule, law includes regulation, law includes notification, law includes even custom or usage, having in the territory of India the law of the force of law. So, my dear friends, Article 13, sub-article 2 is a very, 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 very important provision which says that any lawmaking exercise has to be in consonance with the constitutional provisions, has to be in consonance with the fundamental rights chapter part 3. And I now read Article 14, the one first fundamental right, that is right to equality. Now, title of Article 14 is right to equality, that is equality before law. Samanta ka adhikar, equality before law, right to equality. Article 14 says the state shall not deny to any person equality before the law or equal protection of laws within the territory. Article 12 definition. Article 13 state lawmaking exercise cannot be in derogation of part 3. Article 14 gives you right to equality. It's a fundamental right. It is that Article 14 which is reservoir of various other rights. What are the various other rights? Right not to be treated in arbitrary manner. Arbitrariness, I told you. Right to be fair and natural justice aspect is also part of Article 14. So, there is various inherent things inculcated in Article 14. Two, I have highlighted natural justice, which is relevant today. And second is arbitrariness. I may tell you, friends, there has been a judgment of the Supreme Court of India in the tax law or in the tax, reported in ITR 5 just Constitution Bench decision. Let me tell you, this is the judgment of 65. This judgment I will tell you all you, because this is one of the very important judgment today. I thought I should share it. This is the judgment. You can all note. Now, this judgment says, this is the judgment of Supreme Court of India. This S.G. Jaisinghani 65 ITR page number 34. It says that in this context, it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law upon which our whole constitutional system is based. In a system governed by rule of law, discretion when conferred upon executive authorities must be confined with clearly defined limits. 65 ITR 34. Now, this judgment of 5-judge bench, as Singhani, I am telling you, this is more than 100% applicable. It is 1967 order, but it is 2024. It is more applicable than it was in 1967. I am telling you with my all respect. And secondly, this judgment of Supreme Court in 1991 says that almost a quarter century back, this court, Supreme Court says in S.G. Singhani, indicated the test of arbitrariness and pitfalls to be avoided in all state actions to prevent that vice in a passage as undone. And Supreme Court says then, after Jai Singhani's case, long strides have been taken in several well-known decisions of this court, that is Supreme Court, expanding the scope of judicial review in such matters. It has been emphasized time and again that arbitrariness is anathema to state action in every sphere, and wherever the vice percolates, this court would not be impeded, that is Supreme Court would not be impeded by technicalities to trace it and strike it down. This is the surest way to ensure the majesty of the rule of law guaranteed by the Constitution of India. So 65 ITR, page number 34, S.G. Jaisinghani order is a very important order, sir, on this aspect. Now, I was reading Article 14, right to equality. I am telling you, I have already told you arbitrariness aspect, 5 bullet points. Please make it we can make it a habit or a, try to explore and navigate that how many decision-making exercises which are done by various regulators and statutory bodies, authorities, are in consonance and satisfying the soul and this provision of Article 14, sir. So, constitutional guarantee of Article 14, that is equality jurisprudence. I have already told you 2 books, Nariman Saab and this Justice Sikri Saab book. Please go through them. You will find that how far Article 14 is one of the most important provision in the Indian Constitution, which substantive. Now, I will tell you, there is a judgment of Justice Khanna. I've thought I would definitely discuss it amongst today's our learned viewers. I'm just sharing with you. This is a judgment, very latest order of now. This is judgment of state of, my friends can note the name of this case because we are discussing Article 14. The name of the case is State of Andhra Pradesh and others versus Dr. Rao VBJ, and the citation is 2024 INSC 894 neutral citation. The author of the judgment is Chief Justice of India, Dr. Justice Sanjeev Khanna Saab, and the date of the order, friends, is the date of the order is, you can note, 25th November 2024, title State of Andhra Pradesh versus Dr. Rao. Now, why this order, to my understanding, is a landmark order of the current Chief Justice of the country? There was a policy government memoranda whose constitutional validity was an issue in this case. Now, what is this government memoranda? This state of Andhra Pradesh, Telangana at that time made some policy, friends, to allot some lands to some privileged class people in a apparent manner which is violative of Article 14. High Court of that state, in this particular High Court, whose decision was challenged by the state, that is the High Court of Andhra Pradesh, in this writ petition, has partly quashed that government memoranda, that is government, notification, saying that it is violative of Article 14 equality clause. Please read this judgment not from this perspective whether it is a tax law order. Please read it from the perspective of this point, that how rich and how wide is the plenitude of Article 14, and how many areas are there where we can use this Article 14 equality protection clause or equality guarantee in our various tax law provisions and in various actions of various tax law authorities. Now, I come to that part, which is the crux of the judgment, where the my Lord Chief Justice Khanna Sahab has very, very painstakingly analyzed the Article 14 ka jurisprudence equality wala in US, Canada, South Africa, various nations. Yes, this judgment is a worth reading judgment for everyone who loves to understand constitutional things, that how Article 14 is being, what you say, compared with the various foreign countries' constitution and comparative article. So I take you friends to the that part which is very important for today's discussion. Sorry. Now this is where that starts. The constitutional validity of this government memoranda GOM, the Supreme Court says short GOM. Now there was I told you there was an issue of allotment of some property to people, immovable property, land, etc., to some privileged class. Whether the state can have arbitrary discretion कि जिसका जैसा मन आया उसने उसको दे दिया, ऐसा होना चाहिए नहीं होना चाहिए. अभी उस कंटेक्स्ट में Supreme Court has posed this question. The question arises is, can the government, like any private individual, have absolute discretion to frame the policy, distribute resources, and enter into a contract with whomsoever it pleases on any terms and condition it so desires? Please note the question. Again, I read. This is very interesting question. And this is typical Justice Sanjeev Khanna, because he has, my lord, has been in Delhi High Court. I had one or two occasions to appear before his lordship when he was in High Court in tax bench. Can the government, like any private individual, have the absolute discretion to frame policy, distribute resources, and enter into contract with whomsoever it pleases on any terms and condition it desires? In my life, I have to yet see a literature man great as Mr. Khanna. So his lordship has very beautifully analyzed that. This is that Royappa's Ramana Shetty judgment, which I was telling you, friend, on Article 14 Justice Bhagwati order. And this is Srilekha Vidyarthi, we have just read. That absolute, this is the judgment on absolute discretion is against Article 14. Now, Supreme Court has called down this point. Para 46, this time and again, this court has held that while power to distribute and redistribute public assets and resources lie within state's discretion, such discretion is not absolute. अब आप यहीं रुकिए, अभी हम नहीं रुकते. My अनुभव and the experience says me that there have been various areas, friends, where there has been absolute discretion. Totally wrong. Totally wrong. And I'm telling you, I'm not in what do you say? I'm making a very what can you say? Very humble statement that various acts of various authorities now who are regulating the acts of now auditors, there has to be a serious check on Article 14 also on them, whether they are behaving in Article 14 compliant manner or not. I hope all of you get what I'm submitting. So Article 14 and the logic of equality imposes powers on the exercise of discretionary powers. It cannot be questioned and contested that state policy must, any executive action, Supreme Court Justice Khanna reiterates very sweetly and succinctly, executive action and state policy must satisfy the rigors of Article 14. Now, this leads to subsequent inquiry. Now, this is very important inquiry. How do we ascertain whether a state policy or executive action has violated the fetters imposed by Article 14? In other words, what are the tests applicable to evaluate the legality of state conduct in this article? Now, Supreme Court says, how we analyze? What is the way? What is the test? What is the means? What is the method? What is the technique? What is the analysis examination area? So the crux of the judgment starts here, and I'm telling you, it is like to me, Ramcharitmanas and Sundarkand. The test of reasonable classification developed several decades ago constitutes to be a dominant test permitting our constitutional discourse. It consists of two prongs. The classification must be, now what is it talking about? The Supreme Court is saying any action of any state authority or any lawmaking authority, if it has to be in accordance with Article 14, it has to first satisfy the test of reasonable classification. Now, what is reasonable classification? Then it says कि वो two prong test पूरा होगा. What is first prong? classification must be defined on intelligible differentiate, some intelligible sense. How you difference between two people. Various areas are there where tax authorities or the regulators or the lawmakers distinguish, keeps some people out of a particular provision and brings it. Now that has to first satisfy the test of Article 14, that is reasonable classification. There has to be intelligible differentia. Then that differentia must have rational relation with the object sought to be achieved. These are two very important different prongs. Please don't mix it. First is intelligible differentia, which distinguishes between the people, and second, the rational connection between the object which the lawmaker is seeking to achieve and the policy in question and the provision in question. So reasonable classification test, friends, have to be met first. My purpose to show this decision is one more important and serious thing. This is para 52. The basis of classification and object of legislation are distinct things. Article 14 postulates the need for rational nexus. Therefore, the mere designation of a classification based on identified objective does not lead to an automatic satisfaction of Article 14. Please mark these lines. Mere classification designation does not do Article 14 pura ho gaya. It has to have proper nexus with the law-making objective of the law and the difference which you are making. So Supreme Court says you have to be careful that object of law and classification are two different things. Or then the Supreme Court has also analyzed foundation of arbitrariness. There should not be, and see, this line is very important. Last, I have underlined Article 14 of the Constitution prohibits class discrimination by conferring privileges or imposing liabilities on individuals arbitrarily selected from a large group in similar circumstances concerning the privileges sought to or the liability. The classification must never be arbitrary, friends, must never be artificial, must never be evasive. The classification should not be arbitrary, should not be artificial, should not be elusive. And Supreme Court has analyzed the history of evolution of arbitrariness foundation of is in the context of classification were led by Justice Bose in these judgments. I move further. Now, this is para 56, you all can note, is also one of the very important. It follows that rigors of Article 14 cannot be interpreted in a narrow, pedantic or lexicographical manner. The doctrine of classification is neither a mere restatement of Article 14, nor it is the objective and end of that article. In a catena of judgments, this court has held that reasonable classification doctrine is a judicial formula to assess whether legislative or executive actions are arbitrary, thus amounting to denial of equality. It is arbitrariness that lies at the heart of the reasonable. Now, arbitrariness is at the heart of the law. The principle of reasonableness, both legally and philosophically, is an essential element of equality or non-arbitrariness, pervading Article 14 like a brooding omnipresence. There is a substantive equality point, friends, which the Supreme Court has culled out in this case, that now Article 14, and this is one of the very, very important paragraph of the entire judgment of Justice Khanna Sahib in Supreme Court. Over the years, there is a discernible and marked shift from mere formal equality to the broader concept of substantive equality. Please note, my friends, that there is a difference between just a formal equality and a substantive equality. Now, Supreme Court says Article 14 attacks formal equality wala aspect also address and substantive equality wala aspect. What is this substantive equality wala aspect, which is new area, new horizon, new area where the taxpayers, etc., can check telling the validity of a provision on substantive equality. Now, it says on one hand, substantive equality focuses on correction of historical wrongs, checking stereotypes, stigma and prejudice. While on the other hand, it also scrutinizes if a law or policy is inherently discriminatory. I have seen various provisions, various areas where this sentence is applicable, that substantive equality scrutinizes if a law or policy is inherently discriminatory. The latter principle applies when the legitimacy of the object is flawed and manifest arbitrariness. So, substantive equality test, friends, which is propounded by Justice Khanna Sahib in this order, is a landmark judgment. And it says that, concludes here, substantive equality wala paragraph. He concludes somewhere later on. He says substantive equality aspect is also to be addressed. This is the paragraph, I believe, 73 number. The substantive equality test will also fail in case the legislation or the policy in its operation result in indirect discrimination. I have seen various areas this paragraph 73 of the judgment of Supreme Court can be used. So substantive equality aspect, I hope you have all understood. I follow further. Article 14, apart from Article 14, there are two more important fundamental rights. Article 19, right to carry on trade, etc. And Article 21, what you say, right to liberty and personal thing. Now, Article 19, there is a right to freedom, this freedom to carry on business, etc. So that can be only curtailed on reasonable restriction. Reasonableness, I am telling you, is a very important word used in uh, various articles, that if any curbing has to be done there, restriction, then it has to be reasonable. It can't be unreasonable restriction, sir. So Article 19 gives you right to carry on trade, etc. And Article 21 to my mind is very important, like Article 14. I will read Article 21 also because it has very serious role in chartered accounting. Now, various arrest provisions are there in GST, etc. Article 21, please read in the light of arrest, etc., where my liberty is snatched. Article 21 says protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by the law. Liberty is a right to liberty. Now, heading of Article 21 is protection of life and personal liberty. Protection of life. Life को underline करिए. Various important, thousands of rights, friends. Right to health, right to clean environment, right to education. I'm telling you, Article 21, like Article 14, is also a powerhouse of various rights. Article 21, right to liberty. For my perspective, today's discussion, liberty is a very important point. Various authorities who arrest people at their whims and fancies in a carte blanche manner. Sorry, Article 21 is a very, that's why bail jurisprudence has developed. And that's why courts have said arrest and person's liberty should not be detention, arrest, all should not be done in a mechanical manner or without following the strict, particular relevant mandate of the law, judicial points of the law. So Article 14, 19 and 21 are three important fundamental rights, and Article 32 is also a fundamental right that a person can move directly to the Supreme Court if there is a violation of fundamental right, which Dr. B.R. Ambedkar says that with our entire constitution will be nullity without Article 32. So Article 14, Article 19, Article 21, Article 32, all you have noted. Now, what are the other important articles in the Constitution of India which are of practical use? I am telling you. Article 136, special leave petition, I told you. Article 226, writ petition, we have discussed. Now, there is a very important article, sir, Article 265. It says that no tax can be collected except by authority of the law. I will read that because it has very serious significance, sir. And in my opinion, whenever we challenge any particular action of a tax authority, all of you should have in your back of your mind this Article 265, sir. What it says, the heading of Article 265 is tax not to be imposed save by authority of law. What is the heading note of Article 265, friends? Tax is not to be imposed save by authority of law. Without authority of law, there cannot be any taxation. So note the content of Article 265 is no tax shall be levied or collected except by authority of law. I have got one decision to share with you, which is a landmark decision, not to go, just you can note one decision this. If you can understand this particular order, to my mind, we will be able to understand what is Article 265. Now, please note this order of Supreme Court of India in case of Mafat Lal Industries versus Union of India. I believe you have all on your screen this judgment. Mafat Lal Industries versus Union of India, para 160. The citation is 1997, 5 SCC 536. Para 160, I am reading, friends. The constitutional embargo, that is Article 265, is both on levy and collection of tax without authority of law. It has been repeatedly asserted by the courts that every taxing law has three parts. First is charge. The second is computation, which results in demand of tax. And third is recovery of the tax. Three components. Please understand, very interesting. Charge, computation, recovery. Constitution has enjoined that there must be a valid levy. The levy has also been understood in a broad sense in various cases to include not only the imposition of the charge, but also the whole process of. So what Supreme Court has said in this friends, the constitutional guarantees that not only the levy should be lawful, but also the collection of the tax must also be done by authority of law. The state is not permitted to exact any tax from any citizen without authority of law and without following the procedure laid down by the law. You know how many cases this procedure laid down by the law and the norms of the law, authority of the law are breached? You will see. The guarantee has to be strictly enforced not only in the matter of levy, but also in the matter of collection. So Supreme Court in Mafatlal Industries in this para 160 says the levy and collection part indicates that all steps in making a man liable to pay tax and execution of tax must be in accordance with law. कि जितने भी steps हैं, baby steps, step 1, step 2, step 3, reopening notice, demand notice, hearing notice, show cause notice, everything has to be in accordance with law. Then only Article 265 will be satisfied. So one cannot say if ultimate demand is okay, then all other steps which are prior steps are also okay. No, no, no. All steps from beginning to end should be compliant with the authority of law concept and Article 265. Please. So Mafatlal Industries, you have understood. And Article 265, I am telling you that reopening, show cause notices, application of mind, legal provisions kept at bay, technology and insight portal being used. So Article 265, Atma, I believe earliest times is not being properly taken care of. Soul of Article 265 has to be properly understood. Then is Article 300A also, friends. You know, at a time, right to property was a fundamental right somewhere in the past. But now there is a difference between fundamental right and a constitutional right. Now, fundamental right we have understood in part 3. They are in part 3 of Constitution. Now, what is difference between fundamental right and constitutional right? That any law made in violation of fundamental right will be invalid. But that is not so with other constitutional rights. So there is a very important constitutional right in Article 265, which we have understood that no person can be taxed except by authority of law. There is another important protection, friends, constitutional protection and constitutional guarantee that is in Article 300A. I am reading it because this is commercial litigation. This is very, 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 very important. Right to property, Article 300 capital A. It says persons not to be deprived of property without authority of law. I repeat, persons not to be deprived of property save by authority of law. कहाँ कहाँ लगेगा? Sara seizure, confiscation, detention, all these seizure, confiscation, all these things which the authorities do, you have to be very importantly understand Article 300A. Article 300A heading, right? Persons not to be deprived of property save by authority of law contain no person shall be deprived of his property save by authority of law. You know, Justice Narasimha, or one of the favorite judges in the Supreme Court, has written an order. I will show that order. And what a classical order on 300A. His Lordship has stated in a judgment, recent judgment, where his Lordship has says that what is article now? Please, all of you can I have less time, but this is worth reading. Treatise on Article 300A and the dimensions of Article 300A captured by Justice Narasimha, Supreme Court of India in Kolkata Municipal Corporation versus Bimal Kumar Singh. The citation of this order, friends, is this order is the citation of this order is 2024 INSC 432. Now, there are various sub-elements of Article 300A, which my lord has stated. These are the points. See, Article 300A has been, paraphrased and culled out in step-by-step form. When and how, in what manner state can take a property of a particular citizen and person. And what are the 7 sub-rights? 7 sub-rights have been identified by the Supreme Court. Duty of the state to inform the person that it intends to acquire his property, the right to notice. First right is right to notice. Second, the duty of the state to hear the objections of the acquisition, that is right to be heard. Then right to a reasoned decision. Then right to acquire only for public purpose. Duty to acquire for public, the right of restitution and fair composition, and right of expeditious process and right of conclusion. So all these 7 sub-rights read by Justice P.S. Narasimhan, Supreme Court of India in Article 300 capital A as a 7 sub-rights part is a very important thing. So why I am telling you Article 300A has its importance in commercial litigation, various tax laws and corporate laws and ED, we see a lot of confiscation, attachment and seizures, which are arbitrary, which violates Article 300A. You can note on Stridhan being confiscated, Stridhan being seized, Stridhan being taken away by the income tax authorities is totally, Article 300A has a very serious importance, friends. So we have discussed Article 14, Article 19, Article 21, Article 32, Article 136, Article 226, Article 265, Article 300A. So in my this last 90 minutes exercise with you, maybe if it is, I don't know, I'm sorry if it is, I have bored you, but yes, this is very critical that we have a temperament and a constitutional approach to understand the things and situation in the constitutional perspective. I was telling you, I have noted various words जिसका सामने constitutional, like constitutional scheme, constitutional values, constitutional sense, constitutional goals, constitutional guarantee, constitutional courts, constitutional remedies, constitutional adjudication, constitutional limitation, constitutional provisions, constitutional study. So there is a whole lot of word of constitutionalism. So all these things are pointing out to one direction, friends, that judicial review power, rule of law thing, and arbitrariness aspect, Article 14 thing, Article 265 thing, Article 300 thing, and the judgments of Supreme Court, which we have discussed by Justice Sanjeev Khanna Saab, by Justice B.R. Gavai Saab, and by Justice Surya Kant Saab, and Dr. D.Y. Chandrachud, in some decisions when before retirement, he has said that now natural justice is constitutionalized. It is part of Article 14. Please don't mistaken. Nobody, no authority can say that we will not give you natural justice because it is not written in the statute. I am telling you, it is now part of Constitution, Natural Justice Article 14. That is Supreme Court Justice Chandrachud has reiterated in various orders before his retirement that natural justice has been elevated to a constitutional status in Article 14. So the future of what you say constitutional thing is, I believe, as far as our Supreme Court is concerned and high courts are concerned, our courts are doing a great deal of justice. They are acting like a sentinel on the QY. You know what is sentinel on the QY means? Sentinel, a guard on the alert. And they are definitely taking various constitutional challenges in the letter and spirit. And so I know many people may have a point that how far we can go for constitutional adjudication and constitutional litigation. But sometimes we have no choice, friends. And the writ petitions versus this constitutional remedies versus statutory remedies, you have to be very careful. Ek jagah remedies and statutory remedies at one place, and at one place you have constitutional remedies. You have to elect your remedy in a proper manner. Just because I am a lawyer, I am practicing in high court, I am not advocating that constitutional remedy you go. But we have to have very serious understanding that how far and how much we should use constitutional remedies vis-a-vis the statutory remedies. And with these words, I am already 1351. So my good friends can ask any question. My team who has been there from the C Institute side, I'm thankful to them that they have cooperated and they have accommodated me and they have definitely bear with me for this thing. And I'm thankful. And with one chopai of Ramcharitmanas, I would definitely just recite one chopai of the Ramcharitmanas, friends, that जाहि विधि होए नाथ हित मोरा करहु सुबेग दास मोहतोरा. जाहि विधि होए नाथ हित मोरा करहु सुबेग दास मोहतोरा. सीता राम चरण रति मोरे अनुदिन बढ़ऊ अनुग्रह मोर. So with these words, I conclude my, and I'm sorry if I have not been able to cover anything. And if you have any question, you can put it right away. I will answer. I have some family health issues with my child. So sometimes it's not possible for me to reply on mail. Kindly bear with me, please. Thank you. Madam Nisar, there is any query? We can end up. It's already 1352. Or you want me to? You want me to continue for more? So I believe I have what I have stated in our flyer. I have covered everything, and all the 4 judgments or 3 judgments of the Supreme Court and 2-3 books I have also recommended. This I am end with my notes.